the record of this House has it that this bill is actually intended to rectify, to remedy the existing defects in the law. The last time this Parliament handled this bill was 2005, and the Uganda People's Defence Forces Act 2005 was enacted in 2005 to provide for the regulation of the Uganda People's Defence Forces in accordance with Article 210 of the Constitution. It repealed...
Honorable, I meant Honorable Muhoozi, not Muhoozi. Muhoozi, not Muhoozi. And Honorable Tafire.
It repealed and replaced the Armed Forces Pensions Act, Cap 295, and the Uganda People's Defence Forces Act, Cap 307. Since 2005, the defense sector has undergone significant transformation arising from both emerging threats and opportunities. Several of them were unforeseen and not adequately addressed by the Uganda People's Defence Forces Act, Cap 330. The Act, for instance, did not provide for the provision of health care for the officers and management of militants. It did not also provide for the management of military veterans, management of pension and conferring of service medals by the defense forces. It is important, Right Honorable Speaker and colleagues, to note that since 2005, the administrative structure of the Uganda People's Defence Forces has evolved. This in turn has led to the Special Forces Command and the Reserve Forces being elevated from divisions under the Land Forces to independent services. The amendment before you today has taken this into account. Additionally, following the judgment of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazikuruka, that name there is need to align the provisions of the Act with the Supreme Court decision. This bill accordingly gives effect to the orders and recommendations of the Supreme Court. And Right Honorable Speaker and colleagues, I believe that the justifications as are embedded in the remedies proposed in the bill, one of them is to align the Act with the new government policies and the command, control, and other administrative structures of the defense forces. Another one is to improve the welfare of the officers and militants of the defense forces, to address the glaring gaps in health care by providing for health care for officers and militants. 3, to harmonize the management of military veterans. 4, to provide for the decentralization of pension authority from the Ministry of Public Service to the Ministry of Defense and Veteran Affairs. 5, to enhance disability compensation to enable fair payment of compensation to officers and militants of the defense forces for injuries sustained while on duty and address the resulting challenges faced by officers and militants living with post-traumatic stress disorder. 6, to restructure and reestablish the courts martial in the defense forces in accordance with Article 129(1)(d) of the Constitution and prescribe their jurisdiction to provide for the membership and qualification of presiding officers of the courts-martial and for the independence of the courts-martial. 7, to provide for appeals from the courts-martial. 8, to prescribe exceptional circumstances under which civilians may be tried by the courts-martial. Next is to establish a military courts department which shall be responsible for the administration of justice within the defense forces and provide for its membership. Again, to establish a disciplinary unit within the defense forces which shall be responsible for the discipline of the members of the military courts department. And finally, on that is to prescribe the arms and ammunition which are the monopoly of the defense forces and classified stores of the defense forces. Right Honorable Speaker and Honorable colleagues, this law is not about civilians being before courts-martial. This law is about civilians who voluntarily acquire arms, equipments of violence. This law is also about the civilians who voluntarily masquerade as militants. This law is about those who would commit offense with the military or with the help of any military officer to be tried as proposed. Right Honorable Speaker, I want to dispel the fear that this law is targeting 45 million Ugandans. That's a lie. This law is targeting those people who have preoccupation in their minds to commit offense against Ugandans. This law is to protect Ugandans, the vulnerable Ugandans, against violent people who have firearms or who behave like military personnel. I beg to submit.
Thank you.
Honorable Speaker, and I will summarize. On the 13th May 2025, the bill was referred for the first time reading to the committee, and according to Rule 200, a consolidated.
Yes.
The chair of the committee intends to dissuade the House that there is no dissenting report. There is a dissenting report that was submitted to the chair of the committee, and rightfully so, he should have probably made us aware that it is there and almost signed by half of the committee.
The chair will bring it that. Just be patient, it will come. The chair, after reading his report, will call for the dissenting what? Views.
I have been handed over the minority report. I wish to lay the minority report. And there was no intention whatsoever, but the fact is, if there is a second one,
proceed.
you present. Right Honorable Speaker,
And honorable members, stop smuggling minority reports in the House. The reports must be received, we upload them, and we handle them.
Thank you.
Nobody will be denied to present a minority report, but just bring them in a formal way.
Right Honorable Speaker, I wish to present the report of the Consolidated Committees of Defense and Internal Affairs and Legal and Parliamentary Affairs. This bill addresses the policy principles, and briefly, it streamlines the composition of the defense forces and establishes healthcare service for its members. The bill creates a medical board. It defines service offenses. It defines.
A report is being presented.
Let him finish his report.
Yes.
Hansard, capture all the reports. Capture all the reports. Yes, Honorable Wilson, go ahead.
Thank you, Right Honourable Speaker.
Are you Wilson? What is it?
Right Honourable Speaker, I sit in the Committee of Defence and Internal Affairs. Right Honourable Speaker, you gave the committee the task to look at the bill and come up with the report. And when we were writing the report on Monday, before we reached half of our report, the chairman told honorable members that they are going to Entebbe to attend the caucus, and they will come back. We shall continue with the report. Right Honourable Speaker, the chairman did not come back, and we did not continue with writing our report. Is it procedurally right, Right Honourable Speaker? I don't know where the report came from. Let the chairman clarify to members, because we did not complete writing our report on that day. Right Honourable Speaker, we need to be very serious. And it's so bad to keep on smuggling what is not agreeable by honourable members. Where did you get this report from? Yet the committee did not complete. Right Honourable Speaker, let us put the record right. In fact, we did not complete working on this report. And we did not process it.
Honourable, where did you get your dissenting views for you to write a minority report? Because the minority report is, sit. The minority report is signed by you. Where did you get the dissenting views? Chair, continue.
In its composition of defense forces, it establishes the health care service of members, it creates a medical board, it defines service offenses, military courts, and reserve force, while restructuring the courts martial per Article 129, 1D of the Constitution. The proposed qualifications of the chairperson of the courts martial to ensure independence and allow for appeals. This bill specifies circumstances under which civilians may be subject to military law and outlines the offenses tried under courts martial. Additionally, Right Honourable Speaker, this bill establishes a military courts department, a disciplinary unit for enforcing discipline within the military court system. It prescribes defense forces exclusive arms and ammunition. It manages veterans affairs and repeals the Uganda Veterans Assistance Board Act Cap 221. The Uganda People's Defense Forces has provided under Article 2010 of the Constitution, replacing the Armed Forces Pensions Act Cap 295 and Uganda People's Defense Act Cap 307. Notably, the defense sector has undergone significant transformation since 2005, driven by emerging threats and opportunities, many of which the Act does not adequately address. The Act did not include health care for the officers and militants, management of military veterans, pensions management, or service medals conferred by defense forces. Since 2005, the UPDF administrative structure has changed significantly, with Special Forces Command and Reserve Force elevated to independent services. The Uganda People's Defense Forces Amendment Bill 2025 reflects this evolution. Additionally, Right Honourable Speaker, the bill seeks to align the Act with the Supreme Court decision in the Constitutional Appeal number 2 of 2021, which is Attorney General versus Honourable Michael Kabaziguruka. What are the objects of this bill? It seeks to amend the UPDF Act Cap 330 to streamline the composition of the organs and structures of the defense forces. It establishes the health care service for members of the defense forces. It establishes a medical board. It provides for the definition of service offenses, the court martial, military court, and reserve force. It provides for the restructuring and establishment of the courts martial in the defense forces in accordance with Article 129(1) of the Constitution and prescribe for their jurisdiction. This bill provides for the membership and qualifications of the chairperson and the court and the courts martial and the independence of the courts martial. It provides for appeals from the courts martial. It provides for the exceptional circumstances under which civilians may be subject to military law and prescribe the offenses for which civilians may be tried by the courts martial. Right, Honorable Speaker, this bill provides for the establishment of the military courts department within the defense forces. It also further provides for the establishment of a disciplinary unit within the defense forces, which shall be responsible for the discipline of the members of the military courts department. Also prescribe the arms and ammunition which are a monopoly of the defense forces and classified stores of the defense forces. It also provides for the management of the Veterans Affairs. It also repeals the Uganda Veterans Assistance Board, CAP 221, and for related matters. Right, Honorable Speaker, for the record, we consulted as is demanded by the processing of the bill. We met and held discussions, constructive ones, with stakeholders, like the Ministry of Defense and Veterans Affairs. We also met the Attorney General. We held discussion with Office of the Director of Public Prosecutions. While processing this bill, Right Honorable Speaker and Honorable colleagues, we also entertained private legal practitioners. In this case, Counsel Jude Byamukama. We also entertained and granted audience to Kampala Reduction in Force veterans of the UPDF, who gave us enriching perspectives and testimonies. We did document review. We looked at the Succession Act. We looked at the Constitution of the Republic of Uganda. We looked at the Defense UPDF Act, CAP 330. We looked at the Pension Act, CAP 89. We looked at the Uganda Veterans Assistance Board, Uganda Veterans Assistance Board Act, CAP 221. We looked at the Human Rights Enforcement Act, CAP 12. The following are the salient observations on the bill. 1. Military justice and legal framework of the courts martial. The committee recognizes that one of the objectives of the bill is to implement the Supreme Court's declarations in Attorney General versus Honorable Michael Kabaziguruka, Constitutional Appeal number 2 of 2021, delivered on 30th January 2025. The committee has reviewed the bill's proposals on military justice and courts martial framework. The findings reveal concerns about compliance with constitutional principles, judicial independence, and administration of military justice. 611, the trial of civilians under military law. Clause 29 and Clause 30 of the bill address individuals under military law and the court-martialing of civilians. Clause 29 revises Section 119 of the Principal Act to clarify who falls under military law. The amended Section 117 stipulates that all defense forces members are governed by military law. Meanwhile, Clause 30 introduces a new Section 117A detailing additional individuals who may be governed by military law. This section specifies persons not part of the defense forces that may be subject to military law under exceptional circumstances. From the above, the provisions indicate two categories of individuals under military law: a member of defense forces and a civilian involved in activities outlined in Section 117A. The committee notes that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This, Attorney General versus Michael Kabaziguruka, which included several observations, recommendations, and other regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military law. Some witnesses objected to trying civilians in military courts, arguing that Supreme Court's interpretation prohibits such actions. In contrast, other committee members and stakeholders, including the learned Attorney General and the Minister of Defense, contend that the Supreme Court did not fully ban civilian trials in military courts, suggesting instead that such a trials could occur under exceptional circumstances. The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the UPDF Act that hold civilian criminally liable is to safeguard national security. The committee reviewed the exceptional circumstances outlined in the bill and determined that certain aspects require revision to align with the legality principle. Specifically, the committee identifies that paragraph D, which allows the trial of civilians in military courts for aiding and abetting individuals subject to military law in committing serious crimes such as murder, aggravated robbery, intent to murder, kidnapping, treason, misprision of treason, or cattle rustling need adjustment since it fails to specify the elements of these offenses. This omission compromises the legality principle defined in Article 28(12) of the Constitution. Furthermore, the committee observes that while civilians are penalized for aiding and abetting these crimes, primary offenders face no penalties. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the UPDF Act ensure a fair trial. This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence. The committee, therefore, recommends that clauses 29 and 30 form part of the bill, albeit with amendments as proposed. 6.12, restructuring of courts martial in alignment with the Constitution, particularly Article 129(1)(d). Right Honourable Speaker and Honourable colleagues, the proposed restructuring of the military courts as outlined in the bill aims to align the unit court-martial, division court-martial, and the general court-martial with the Constitution under Article 129(1)(d) of the Constitution. It introduces provisions on the qualifications, appointments, tenure, and jurisdiction for the service offenses. Additionally, the bill establishes military courts department to oversee justice administration within the defense forces. However, the committee noted that the roles and functions of the military courts department are vague, leaving gaps in oversight and accountability intended to oversee military courts. The structure risks undermining judicial independence. The military courts department includes the head general court-martial as chair, along with military prosecutors, defense counsel, and chairpersons of the military courts. This overlap of judicial and prosecutorial roles is seen as a violation of natural justice principles. It threatens the right to a fair hearing by compromising impartiality of the court. Additionally, a key concern arises from the provision allowing the Chief of Defense Forces, in consultation with the High Command, to assign an acting rank to the head of the General Court-Martial when the accused has a higher rank. While intended to maintain order, this mechanism may introduce bureaucratic delays and allow manipulation of the justice process. For instance, the Chief of Defense Forces could delay rank assignment impeding the prosecution of senior officers. The temporary rank, with its associated privileges, may also incentivize judicial officers to prolong proceedings to retain benefits, hence compromising timely and impartial justice. The committee therefore recommends that the proposals contained in the bill regarding composition and structure of the military courts should be supported, albeit with amendment to engender fair trial provisions as proposed in the committee's amendments. Appointment of the presiding officers and members of the courts martial. Right Honorable Speaker, the committee notes that Supreme Court emphasized that military courts, despite being specialized, exercise judicial power and must therefore uphold the same safeguards of independence and impartiality guaranteed under Article 129 of the Constitution. While the
Is
bill...
it 129 or 128?
I beg you. Guaranteed under Article 128 of the Constitution. While the bill amends qualifications by requiring legal training for the presiding officers, committee expressed significant concern over the appointment process. Currently, all members are appointed by the High Command from a list it generates in consultation with Judicial Service Commission. This system grants the High Command broad powers to appoint members for specific trials, raising serious doubts about the members' independence and vulnerability to external influence. The idea of consulting Judicial Service Commission does not explicitly define the role of Judicial Service Commission in the process of appointment. The committee argues that the Judicial Service Commission should be given a stronger role to vet presiding officers who wield judicial power. The committee contends that military courts must be governed by judicial oath and legal principles. We therefore recommend that persons presiding over military courts should be appointed by the Commander-in-Chief on the recommendations of Judicial Service Commission from the list generated by the High Command. Tenure of service. The bill allows a 3-year renewable tenure for chairpersons of court-martial, but is silent on the terms of other members. The committee noted that secure tenure is vital for judicial independence, safeguarding judicial officers from arbitrary removal or political pressure. A 3-year term is inadequate, and unclear removal grounds for members create insecurity, risking impartiality. Citing Justice Asaph Ruhinda-Ntenje and another versus Attorney General, Constitutional Petition number 33 of 2016, which declared fixed-term contracts for 5 years for all members and the defining grounds for removal to protect judicial independence. The committee recommends that a term of all members be increased from 3 years to 5 years and is eligible for reappointment. 2, that the term should apply to all members of the courts martial and not limited to the chairperson as proposed in the bill. Appeals from decisions of courts martial. The bill permits unit court martial to the division courts martial to the general courts martial, and from the general court martial to the Court of Appeal, with the Supreme Court as the final appellate court. The Attorney General explained that since the High Court lacks appellate jurisdiction over capital offenses, appeals for such cases must lay directly to the Court of Appeal. The committee agreed with this reasoning, but raised concerns about the practicability of requiring officers and soldiers in remote areas to travel to Kampala for the General Court Martial appeals. This could be costly and could hinder access to justice. Additionally, the right to appeal where the aggrieved party is dissatisfied with the unit court-martial decision has only right to appeals. While a court-martial decision can be appealed to the Supreme Court, were viewed as unfair. The bill restricts appeals on legal matters, making decisions of the chairperson of the unit and the division court-martial final. The committee deems this untenable as it prevents parties from challenging potentially erroneous legal decisions, risking miscarriages of justice. The bill's clauses on the appeal and enforcement of sentences, particularly regarding the death penalty, were also problematic. The phrase of notice of intention to appeal differs from a formal notice of appeal, creating ambiguity and risk that death sentences could be executed before appeals are determined, violating Article 22(1) of the Constitution. This article guarantees that no person shall be deprived of life except after a fair trial and confirmation by the highest appellate court. We therefore recommend, Right Honorable Speaker and Honorable colleagues, we recommend the following. 1, that appeals from the unit court-martials should lay with the division court-martial. 2, the decisions of a unit or division court-martial on matters of law and facts should be open to challenge. That appeals from decisions of the general court-martial should lay with the Court of Appeal as proposed in the bill. 4, proposed section 2272 should be deleted and section 2273 be aligned with the provisions of Article 221 of the Constitution. Structural reorganization of defense forces. The committee says vital role of Uganda People's Defense Forces that has played in upholding national security and preserving and defending sovereignty and territorial integrity of Uganda. In light of the evolving security threats and expanding military responsibilities, there is a critical need to realign the UPDF structure. Structural reform is based on Uganda's legal framework, specifically Article 2010 of the Constitution that empowers Parliament to make laws regulating Uganda People's Defense Forces, and in particular, provide for the organs and structures of UPDF. Section 2 of the UPDF Act, Cap 330, provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergencies. A significant advancement has been the emergence of Special Forces Command, a specialized allied unit tasked with carrying out specialized missions or operations at the moment's notice, very important persons, protection, and reconnaissance. While it is not legally provided for as a distinct service, the SFC holds a crucial position in linking conventional and special operations, collaborating closely with both land forces and air forces. The committee notes that the bill restructures the UPDF by creating new services such as the SFC and the Reserve Force to improve operational capacity and responsiveness. New organs such as the Joint Military Command and Service Command and staff committees are being established to enhance coordination, policy formulation, and strategic oversight. This reorganization also includes renaming and redefining roles in the command structure for clarity, for efficiency, and alignment with the current security needs. The committee therefore recommends that the proposal to restructure the UPDF to formally integrate specialized units such as the SFC as a distinct service branch should be supported to institutionalize specialized capabilities, enhance inter-service coordination, and ensure compliance with the legal and oversight requirements. On Veterans Affairs, the committee notes that the bill proposes transferring administrative and management of pension and gratuity from the Ministry of Public Service to the Ministry of Defense and Veterans Affairs, aiming to enhance service delivery and more effectively to meet the needs of the military personnel. A key aspect of this reform is the establishment of the Pensions Appeals Board to provide a formal mechanism for addressing grievances and disputes related to pension matters. Additionally, the repeal of the Uganda Veterans Assistance Board Act Cap 221 signifies a shift towards a more integrated and updated legal framework. These reforms also introduce comprehensive provisions for retirement benefits, gratuity, and pensions, including entitlements related to death in service and disability, ensuring improved welfare and dignity for the serving personnel and the veterans alike. The Kampala Reduction in Force UPDF veterans informed the committee that although they voluntarily enlisted in the National Resistance Army struggle, which ultimately resulted in a change of government, they continued to serve in the NRA UPDF until their discharge, which occurred without a proper and formal dismissal. The committee notes that the UPDF has transformed since the 1990s, following significant military downsizing after achieving stability post-internal conflict. This began demobilization efforts, and restructuring of the UPDF alongside pension reforms for veterans. The reduction in force affected thousands of personnel, especially older veterans and non-combatants, aimed at enhancing security and lowering public spending. However, systemic issues in the pension system emerged as many veterans faced unclear entitlements, delays, and bureaucratic hurdles in obtaining their benefits. Scholars such as Obore in 2006 highlight that while legislation aimed to guarantee pension rights, many veterans remain unrecognized due to inadequate documentation or unclear classifications, e.g., informal service or voluntarism, not recognized as pensionable. Thus, the committee believes that while the bill will strengthen the pension and gratuity administration for the UPDF veterans, actual realization of the rights remains uneven for the demobilized veterans. Additionally, the bill currently excludes individuals or militants who retired before its enactment, which lacks a commencement date. Its provisions have no retrospective effect and do not address retired officers and militants. Right Honorable Speaker and Honorable colleagues, we therefore recommend, 1, that decentralization of the pension authority to the Ministry of Defense and Veteran Affairs as proposed in the bill should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike. Welfare and health services. The committee observes that the bill proposes establishing a health care service. I am now addressing committee's concerns and observations on welfare and health services. The committee observes that the bill proposes establishing a health care service for the Defense Forces personnel, creating a dedicated health care service for the military personnel,
let's listen to the
introduces,
report.
Right Honorable Speaker, creating a dedicated health care service for the military personnel introduces extensive health care system, including routine medical care for the dependents of the officers and militants, rehabilitation services, and access to specialized treatments abroad when necessary. Additionally, the Defense Forces Medical Board has been established to manage medical evacuations, to manage medical evaluations, conduct disability assessments, and approve treatment for officers and militants. These reforms are designed to ensure that all military personnel receive timely, effective, and specialized health care during their service and after their service. The committee opines that a dedicated health care service for the defense personnel, separate from civilian, addresses a unique nature of military service requiring specialized, timely, and continuous medical support tailored to risks faced by the defense forces. Military personnel often need rapid access to trauma care, rehabilitation for service-related injuries, and treatment for psychological conditions from combat or deployment. The Defense Forces Medical Board will ensure medical evaluations, disability assessments, and treatment decisions aligned with the military standards and readiness, which civilians' health care may not adequately address. The committee therefore recommends that 1. Establishment and operationalization of a dedicated health care service for the defense personnel, as opposed in the bill, be fully supported and adequately resourced to ensure the delivery of specialized, timely, mission-specific medical care, addressing the unique medical and psychological and rehabilitative needs of the military personnel. Monopoly and security classification. The bill introduces measures to strengthen monopoly and security classification concerning crucial military assets of the UPDF. It specifically outlines which arms and ammunition are solely under the control of defense forces, guaranteeing that these materials remain inaccessible to unauthorized parties. Additionally, the identification and safeguarding of classified equipment and materials will now be regarded as sensitive to national security and will be strictly regulated according to military protocols. These reforms, Right Honorable Speaker and Honorable colleagues, aim to bolster national security, prevent unauthorized access, and uphold operational integrity by ensuring that only designated military officials oversee and protect these assets. However, the committee observes that the classification and the categorization of materials under the exclusive control of the defense forces, particularly military uniforms, can have significant implications for civilian wear. When clothing that closely resembles military colors, patterns, or designs are classified as military property, civilians wearing similar attire or clothing may face restrictions or even legal consequences. This is specifically in context where the resemblance is coincidental or fashion-based rather than intended to personate military personnel. For instance, in the bill under Clause 82, Schedule 7B, several uniforms for ceremonial wear, including ordinary black shoes, kaunda suits in the coffee brown, blue, and khaki, have been categorized as exclusive wear for the defense forces. Yet, these are very colors of clothing and black shoes are seen as ordinary wear by the public. Be that as it may, the committee asserts that civilians wearing military-style attire and berets, even without official insignia, significantly risks military identity, public trust, and operational scrutiny. Such apparel can confuse the public, undermine military distinctiveness, and grant an earned authority to those not following military codes. In operational or emergency situations, the difficulty in distinguishing trained service members from similarly attired civilians may compromise coordination and increase risks, potentially damaging the armed forces' professional image. Recommendations. We therefore that Schedule 7B should be amended to include a requirement for marking military stores with the logos and insignia of the UPDF, thereby distinguishing them from civilian items. 2, that a provision should be inserted to restrict the wearing of camouflage military-style uniforms and berets by individuals who are not part of the military. Conclusion, Right Honourable Speaker and Honourable colleague. We therefore recommend that the bill be considered for the second reading, subject to the proposed amendments attached hereto and any other modifications the House may propose and approve. Right Honourable Speaker and Honourable colleagues, I beg to report.
Thank you so much. From Junior, Okot Moses Junior, please present your report. Go to areas of dissent.